object.
Your Honor, I object!
Your Honor, I object. We've all heard this in movies and TV shows, but do you actually know what it means? What happens after a lawyer objects? What about words like hearsay, perjury, or cross-examination? These words aren't just legal jargons. They can determine the outcome of a case. Welcome back to English Luminaries. Today we're stepping into the courtroom, breaking down the legal vocabulary in a way that is clear, engaging, and easy to remember. By the end of this video, you understand these words and use them like a pro. But before we get into, like, subscribe, and share it with anyone who might need it out there. Let's dive straight in. Let's start with one of the most dramatic words in a courtroom: objection. Lawyers use this when they disagree with something happening in the court. Maybe the other lawyer is asking an unfair question, or the evidence is unreliable. For example, objection, Your Honor. That question is misleading.
Objection, Your Honor.
Objection, Your Honor.
Objection, Your Honor.
Now, the judge has two options. If they agree with the lawyer says, they say sustained, which means the lawyer was right, and the question or statement won't count.
Objection sustained.
And if they disagree, they say overruled, which means the trial continues as normal.
Objection overruled.
Imagine you're watching a courtroom drama. When you hear objection, now you'll know exactly what's happening. Let's talk about this word, hearsay. This is when someone tries to use a statement that they didn't hear firsthand as evidence. Courts don't allow hearsay because it's unreliable after all. How do we know it's true? For example, a witness says, "My friend told me that the suspect was at the crime scene." That's hearsay because the witness didn't see it themselves. Unless there is a solid proof, the hearsay isn't usually allowed in a court.
It's probably all hearsay anyway, and I don't want to say anything that could be taken the wrong way.
It's convicting people by rumor and hearsay and innuendo.
Number 3, cross-examination. Alright, now let's picture this. One lawyer asks a witness some questions. Everything seems fine, but then the opposing lawyer steps up and starts questioning them aggressively, trying to find holes in their story. That's called cross-examination. For example, during cross-examination, the defense attorney exposed the witness's inconsistencies. Basically, it's a way to test whether the witness is telling the truth.
I don't think I should be subject to cross-examination by you, Mr. Garrison.
Now get on with your cross-examination.
The point I'm confident you'll illustrate to the court members under cross-examination.
Speaking of the truth, here's a serious one: perjury. This is when someone lies under oath in court. And guess what? It's a crime. For example, if a witness provides false testimony, they can be charged with perjury. Lying in court isn't just wrong. They can change the outcome of a case. So, perjury is taken very seriously.
Be held under arrest for perjury.
He was only convicted of perjury.
I'll do anything I can because Frank Gallo's about to commit perjury and Robert Zane knows it.
Now let's talk about a phrase that's key in criminal trials: beyond the reasonable doubt. It means for someone to be found guilty, there must be no reasonable doubt in anyone's mind. Even if one juror thinks, I'm not sure if they really did it, then the verdict should be not guilty. By the way, juror is a member of jury. For example, the prosecution must prove the defendant's guilt beyond a reasonable doubt. In other words, 100% certainty is required before someone is convicted.
The prosecution seems unable to present any proof of guilt beyond a reasonable doubt.
Is Father Richard Moore guilty beyond a reasonable doubt of negligent homicide?
Number 6, plea bargain. Now imagine someone is accused of a crime. and they know that the trial might not go in their favor. Instead of risking a harsh sentence, they make a deal with the court. And this is called plea bargain. Basically, they plead guilty to a lesser charge in exchange for a lighter punishment. It saves time, but it also means they admit guilt.
At first, they charged him with attempted murder, but then they plea bargain that down to assault with a deadly weapon.
The city of Minneapolis does not wish to pursue a plea bargain in this case, Your Honor.
Open up, maybe we'll let you plea bargain.
Now let's move on to a powerful legal document, a subpoena. If someone receives a subpoena, it means they must come to court and testify or provide evidence. They don't really have a choice. For example, the journalist received a subpoena to testify about the leaked documents. Ignoring a subpoena can lead to serious consequences, including legal penalties. And by the way, penalty means punishment.
No, it's a subpoena.
If the U.S. Justice Department sent us a subpoena, it would become papier toilette.
Let's subpoena work logs, employee records, start with everybody who lives in the town.
Number 8. Mistrial. Sometimes things go wrong in a trial. Maybe the jury is biased. Maybe there was a huge mistake. Or maybe new evidence changes everything. And when this happens, the judge might declare a mistrial, meaning the trial is cancelled and must start over. For example, the judge declared a mistrial due to jury misconduct. It's like pressing the reset button on a case.
Two sweetest words in the English language. Mistrial.
All it's meant to do is just throw our focus off so that we can just move toward a mistrial.
Number 9. Acquittal. If someone is found not guilty, they receive an acquittal. It means that the court didn't find enough evidence to convict them, so they're free to go. For example, the jury's verdict resulted in an acquittal, and the defendant walked free. But remember, acquittal doesn't always mean innocence. It just means that there was not enough proof to convict.
All of us, acquittal after acquittal after acquittal, until the stench of it reaches so high and far into heaven.
Carly's acquittal for the killings of 2 white men will do more for the black people of Mississippi than any event since we integrated the schools.
Finally, let's talk about the moment when someone is officially charged with a crime. This is called an indictment. For example, the grand jury issued an indictment against a suspect for a fraud. An indictment means there is enough evidence to bring the case to the court, but it doesn't mean the person is guilty yet.
Chances are you won't even get an indictment.
Well, that's quite an indictment coming from a Corleone.
And imagine how impressed I'll be when you get an indictment.
Now that you know these powerful courtroom terms, try using them in your own example and comment them below. I'd love to see what you come up with. If you enjoyed this lesson, don't forget to like, subscribe, and turn on all notifications so you won't miss any advanced English lessons. Because remember, words are power, and now you've got the vocabulary to command the courtroom. See you in our next lesson.